Good evening, everybody. From the law firm of Shihab Burke, we begin our 1 hour get together today. And we got a lot to cover, but before we do that, let's do a quick introduction. I'm Sam Shihab with the law firm of Shihab Burke.
I'm Brian Burke from that very same place.
And we practice immigration law in Columbus, Ohio, Dublin, Ohio, throughout the U.S. and throughout the world. We do employment immigration law and we do family immigration law. And we spend 1 hour with you every week at 6 o'clock to bring about a discussion of anything of interest to the immigrant community, any changes in the law, any event that's important to share, listen to you, take your questions and answer questions and give you some guidelines. And we got a lot to cover today, Brian. We have, first of all, the Emergency National Security Supplemental Appropriation Act of 2024 was not an emergency enough.
Yeah.
The House would not even bring it to the floor for discussion.
Yeah, I mean, last week at this time, they had just released the text of that bill, and it was exciting for us because there was actually, even though we got the impression a week prior that there was no employment-based bits in it, there were some crumbs was the terminology we were using. And then, you know, everybody in the House said, oh, not a chance. Not a chance are we going to even consider this thing, and it's thereby dead on arrival. I still call it, I still say it has some value. It shows you where the Senate is thinking in terms of a bipartisan agreement on employment-based immigration matters, and their answer is essentially some more visas for a couple years, no radical changes, some more extra 18,000 visas for employment categories a year, and maybe a couple benefits for H4 dependents, H4 kiddos. Give them some work. There's a couple interesting things in there, but
it's done.
Yeah, it's done.
It's
the
dead.
Bottom line. It is dead.
Here comes another hope. Here comes another opportunity, and we move on.
Some of the most interesting political theatrics I've seen for a long time relating to it, though. It was negotiated, by both Democrats and Republicans in good faith, and then, Republicans said as soon as the text of it came out, they were shocked that they even agreed to something like this in theory, at least.
Right.
Yeah.
So Visa Bulletin is out.
Yeah.
And looks like EB1 moved 1 month for India.
Yeah.
That's a positive thing, and I think
EB1 moves, so they get it 1 month closer to current, and when they're current, well, everybody's current in EB1. Well, that means more stuff can roll down to EB2. He said, crossing his fingers.
And there was also movement in China, I believe, of not as significant.
Well, here, let me check my notes here.
Yeah.
Yeah, let's see here.
Rest of the world final, as you look it up, rest of the world final action date.
No, I don't think there's any other changes on EB1. But
China stayed the same.
Yeah.
So rest of the world, EB1, EB2, and EB3 moved 1 week.
Yeah. Which for me, Sam, in my mind, that's just like classic Visa Bulletin bulletin movement on final action dates. It's historically, what would you see in terms of Visa Bulletin movement on a month? About a week. About a week a month every time you get a Visa Bulletin out. Just I'm thinking, pre-COVID pandemic, in a pre-COVID pandemic sort of world. That's how quickly I used to be seeing the Visa Bulletin move. Yeah.
And that's it.
Yeah.
Okay.
No movement on the filing dates for EB1, EB2, or EB3, which means it's still going to be April before we, as we've said in the past, people are always asking, when do you see date XYZ coming up, in this fiscal year? And your sort of prevailing theory right now is the priority dates is that the dates for filing represent where they think they can get in this year. That's your sort of conservative stance. And my stance is, let's see if they can actually move those dates for filing in April, because it'll say they're basically recalculating the dates for filing on a quarterly basis, which would mean that there's some hope for larger movements as the quarters pass by in the year, essentially.
Yes.
Yes.
Thanks, Brian.
Yeah.
And this third topic that we're going to spend a few moments talking about, or maybe 10 minutes talking about, is the H-1B CAP Lottery Changes and the way they make selections, and how does that impact the process of selection for those who are overseas, hoping for an opportunity to get on H-1B, or those who are here in the U.S. And before we go deep into this, just a refresher, if you are a U.S. master's graduate, so make sure that everybody understands, if you're here in the U.S., you receive a U.S. STEM master's degree, or is it any master's degree?
Any master's.
Any master's degree from an accredited nonprofit institution, right?
Yeah.
Public university?
Yeah, it has to be a public or otherwise nonprofit university. So
you enter in the lottery first to compete on the 20,000 spots that are available.
Yeah, in the master's cap. So yeah, maybe we'll talk about a broad overview of the cap.
Yeah.
So go back 5 years or so. It used to be everybody would send their cases, their completed H-1B cases, to USCIS on April 1st, and you'd hope and pray that a couple months later you get a selection notice, right? A receipt notice for that case. A couple years ago, they implemented an online electronic system. As part of that online electronic system, right around that same time, they said, we're going to change the way we count for the master's cap.
Right.
We're going to say if you qualify for the master's cap being in a U.S. master's degree from a public or otherwise not-for-profit university, a couple other requirements there, but those are the big ones. You're going to basically get a better chance because they're going to put you in the master's cap. We're going to choose the master's cap first, and if you don't get chosen the master cap, you're going to put you in the round with everybody else, meaning you get sort of two chumps at the bit in the selection. But the story of the H-1B registration, the real story of electronic registration, is the means by which you can increase your chances of selection. You know, for the first couple, it's essentially the idea that under the system, prior to what they've announced and are putting in effect this year, that the more times that you register yourself through any employer in the H-1B CAP Lottery, you increase your chances of selection. So if you have two employers looking to sponsor, you for H-1B visas, if you have two chumps at the bit under the old system. If you have 10 employers looking to sponsor you, you have 10 chumps at the bit. And as USCIS sort of put out in their data when they're explaining their reasoning behind the new regulations, there is a person out there who found themselves last year with 80 chumps at the bit, 80 registrations through 80 different companies to get themselves selected in the H-1B cap. And USCIS did not take that very well.
Do you think he's a real person or an avatar that applied 80 times?
I don't know about that person, but I like to think there's
because if I don't want to be that person.
I like to think there's an immigration attorney. Like if you lined up 30 cap registrants, I feel like you could pick that person out of a lineup. I'd say that's the person with the gravitas and gusto in order to get them selected in the cap.
How much effort does it take to get registered 80 times?
I don't know, but
yes.
So the fix.
Well, they created they brought the flame next to the fire and complained about the match and complained about the fire, and then they came around and fixed it. Now the changes in 2025 resolves this problem.
Yeah.
They resolved it. They have done this, said, you companies can collude all day long. We don't care now. And
they may implement a rule later for that, but right now they said they chose not to. Yeah.
Well, then there's nothing to benefit from implementing it, and
Sure.
there's no
That's one of the things
violation
they
of the
mentioned,
law
yeah.
for colluding and bringing people. There's no.
Yeah. Well, why is there no?
So if they're going to be collecting $215 a pop next year, they're going to encourage companies to collude.
Yeah.
It's more money for them.
Yeah. So let's make sure we get the point across. So the new system, it's one person, one passport. No matter how many companies, 10,000 companies register for you, you get one shot in being included in getting selected in the H-1B lottery. That's it. One shot per person per passport.
And that is and there's no mention of collusion or that. The whole thing is gone.
Well, as a guy who had some time this afternoon and spent an hour reading all the government commentary on why they put out these new regulations, all my notes there's all sorts of talk about collusion being this is the reason. But yes, it's that's their solution to the problem. It's collusion bad, one person, one registration, you're done.
Excellent.
Yeah.
Okay, so one entry per passport number.
Per passport number or travel document number as well. Yeah.
And the second significant change that is the byproduct of this rule is that you must have a passport, valid passport to register,
Yeah.
or a valid travel document.
Yeah. And for 99.9% of people, it's going to be a valid passport. If you're asking what's a travel document, the answer should be go get a passport because
Travel documents are documents are typically issued to stateless people.
Yeah.
So be that as it may, you must have a valid travel document or a passport, and that number on that passport is going to dictate the selection process.
Yeah.
And obviously there's discussion about dual citizenship,
Well,
and if you have more than one passport, that was discussed too.
Yeah, dual citizens. You're supposed to use the passport number, the passport and the passport number that you use when you intend to enter the United States. Meaning, they explicitly say in here, no, if you're a dual citizen, it doesn't mean you get 2 chomps at the bit. It means we're going to be looking out for you, and that's a problem. There is no gaming of the system. It's really one registration, one chomp at the bit per person.
Yes.
One individual gets one out of 85,000 chance of getting selected in the. Okay, not 1 out of 85,000, but is only considered once. There's no way you can game the system in theory to get better chance of selection.
Yes. Okay, sounds good. So that seems to me to resolve a big problem.
Yeah.
In the registration this year, the fee for the registration, Brian, remains
$10
at $10,
Yeah.
and next year,
I believe it's $215. I think
Yeah.
it's $215. It's two and some change next year.
$215.
Well, yeah.
Yeah, $215, and be interesting to see whether there will be some lawsuits challenging that fee, because it seems to be incredibly unreasonable.
Considering the amount of work, I mean, do they have to do anything on our end, we're the people who enter these things on behalf of our clients. We have to do some work. We have to, collect some information, enter it in the portal, and potentially verify it, and make sure that there's a bona fide case here.
Yeah.
Whereas the government, I don't know, all that information gets sent to them electronically, and they push a button on a computer somewhere, and
And the list comes out, and
yeah.
emails go out.
okay, well, I'll tell you where the cost is. There's some IT costs, Sam. But this is where I want to get out my calculator, right? On my computer calculator, and I'm going to type in 85,000. That's the total you get, right? Times 215 equals $18 million. I just don't think that system's an $18 million a year sort of burden upon the government.
Sounds like for run an 85,000 selection on a random basis, that sounds like a $1,700 PC. And that's it, really.
I think it's like Sam, I'm going to be generous. I think it's like a $5 million a year investment and like a really nice pizza party for the office after it.
Not even that.
Well, that's why we're lawyers, Sam, and not. I bet the people in our audience could tell us as to what the true value of a project. I bet there's some person out there in our audience who's going, yeah, I bet I could estimate that project, what it would cost the government, let alone its yearly maintenance cost. So I wanted to highlight some other things because, as I mentioned, I spent some time this afternoon reading the government commentary on this regulation.
So the changes and the flexibility that USCIS
Talk about
has.
that, yeah. In terms of those passport, question, because it's a question we're getting quite a bit already. I don't have a valid passport. Can I do it without a valid passport? Again, you need to have it. You should have a passport to register yourself, and basically a valid one on your registration. So it should be valid at the time you register. And the government says the only real exception that we have on that is that if there's a change in your passport between the time when you register and when you file your H-1B petition, right? So they've kind of sort of closed that up a bit. Mm-hmm. I suspect you could always that in the past years where somebody has said, "Oops, guys, it turns out we gave you wrong information," or there's a typo in the data. I am going to cross my fingers and hope, for the benefit of people for whom that happens to, that they'll still accept arguments like that. But how can they with these regulations in place? If the intent is to avoid multiple selections, I don't think they can really accept a typo in a passport number, for example, anymore. So that's something interesting to think about. I guess it's going to be very important to make sure your passport number's in there properly, right?
Yes.
Yeah. So, what else here? Can I bring up my sort of big old highlights?
Yes.
Because I'm clearly excited about this. I read this for a reason, I guess. So one of the things that was a kind of a sort of big topic of conversation during our sessions here was the ongoing investigations relating to fraud and misrepresentation in last year's H-1B CAP registration.
Yes.
That was the big scandal. And one of the highlights here from the government's commentary is there's a lot of talk about fraud in here in their commentary and their regulations. And they say USCIS has already undertaken extensive fraud investigations, denied and revoked petitions accordingly, and continues to make law enforcement referrals for criminal prosecution. Right? And Sam, have you seen any evidence of any publications from the government about law enforcement cases against anybody who is registered in the?
Yep.
Yeah, and they talk in these regulations. So there you go. I haven't seen that either.
I've not seen it either, and that's surprising.
Well, it's surprising
and not surprising.
Yeah, because reading through these, they talk about publishing regulations to forbid multiple registrations from related companies, and they say, well, we don't need that anymore because we have this new rule. But we had the conversation where we just kind of suspected that they don't have the law to really go after anybody on the multiple registration issue.
Not criminally.
Criminally, yeah. I mean, that's that.
I mean, criminally, you have to violate a statute. There's a fraud.
Yeah.
Yeah.
Yeah, I mean, fundamentally, there are people out there who have gotten, somebody sent us a copy of one. A couple folks, some other, not our clients, but came to us looking for advice on those things. And the people who run those companies probably do need, criminal. I haven't seen any sort of evidence of arrest, And it's not in the discretion of USCIS who gets charged. It's the Department of Justice, I suppose. And we're a bunch of immigration attorneys. We're looking for trends in prosecutions relating to immigration fraud. And one of my sort of every couple of months rituals is I'll go to the Department of Justice website and type in H-1B, looking for press releases relating to prosecuting criminal stuff or just any sort of investigations relating to H-1B visas. It's employment discrimination claims, that sort of thing, the usual stuff. So
not H-1B collusion matters.
Yeah.
We haven't seen that.
Yeah.
And we've said before that the regulations were very clear that that is not prohibited in a clear way such that it's a crime.
Yeah, and right after they, there was sort of a disclaimer, not a disclaimer, sort of a promise that you made in registering H-1B applicants, and there's a proposed new version of it for this year.
But these are not regulations.
Yeah, well, the USCIS always takes the position that its forms have the force of regulations.
But it's not.
Yeah.
If there's not published, there's no rulemaking.
Yeah.
And if there's no
rulemaking,
it's not the law.
Let alone criminal. Yeah, I mean, I think that if there are actual criminal cases out there, I suspect that there's some lawyers that are going to have a field day with the government on that issue.
And I tell you what, I mean, forget about that. The changes are positive. The changes are helpful.
Sure, yeah.
And it does something that they've created this. You guys on one side can apply for as many companies as you can. You guys on this other side, employers, cannot talk about what these guys, employees, are doing, or cannot encourage them, or you cannot facilitate that.
Yeah.
But you guys can do it on your own.
Yeah.
How stupid.
Yeah, you're talking about the individual can collude with themselves.
The candidates can do it.
Can say,
the
I'm going to talk to 80 companies, and I'm going to get my self-register with 80 companies, and that's perfectly fine. But as soon as the other companies say, we're going to register, I thought about this scenario, Sam. There's a lot of talk in here, but this makes it a level field for everybody. But what about people who legitimately have more job offers? Shouldn't they have a better chance of getting selected in the CAP? it's really kind of I guess it's a policy shift. It's totally, equal. Everybody gets an equal shot. But that person who convinced somebody to effectively spend $800, on their registration, I would say maybe that person is more
creative.
Definitely a creative individual. I don't know if I want to talk to that person. Has got to be very, very interesting. And how did you get to 80 registrations, my friend? I would like to have that person just examine that person's problem-solving skills, because I'm like, if you want to get yourself selected, being the person with the most registrations is a way to get there,
But whoever did 80 is insane. I mean,
well,
this dude is just completely off the charts.
Yeah. Don't call attention to yourself. I usually when I talk to clients about immigration cases, most types of immigration, you want your case to be uninteresting. You want your case to be as uninteresting as the last one they approved, as uninteresting as the next one they approved. There's exceptions to that, like asylum and emergency things. You want to have a tragic story for things like that. But the average person wants to look very, very normal.
Boring.
Boring.
Yes.
That's a better word. Yeah. And that person is very, very exciting in terms of H-1B registration.
He made it in the Federal Register.
Yeah.
Pretty impressive.
Yeah.
All right. Anything else on H-1B fiscal year 2025 filing, Brian?
Well, I guess I'll sum it up. People have found a way to game the system and make it a very H-1B registration, a very exciting thing in the past. And I can't help but somehow think that somewhere there's got to be a way to make it very interesting and exciting again in the future.
We'll see.
Yeah.
All right, guys. So now we move to our next stage, which is the part that a lot of you guys like, is the discussions we have and the questions and answers, and we try to answer the questions as much as we can, but obviously we don't have all the facts, so our answer is guarded by the fact that we have very limited information. And therefore, don't rely on what we tell you. Consult with an attorney of your choice to help you out with your case. And obviously there's no attorney-client relationship established because we're communicating virtually on the air. With that,
check the first question.
Let's take the first one, Brian.
So, a question from somebody who is a sort of regular viewer here, Emily. You see more than 400K applications for H-1B this year, given the tech layoffs and now individual beneficiaries. So I guess it's do we expect to see more than 400,000 H-1B registrations this year?
So the numbers are in the chart in here. Of prior years.
Yeah,
I think it's 335,000 or something. The non-duplicates.
Yeah.
So that's going to be similar to that number. I mean, I don't anticipate a change.
Yeah, unfortunately, I didn't mark the charts in there. So again, the actual total registrations number was 780,000 last year, which is huge. Emily, I'm just excited to be along for the ride on this one. Will be very interested to see what that number is, but Sam, I'll tell everybody it's sort of a funny thing we do in our office here every H1B CAP season. We have an office bet. It's what's the number going to be, and I always lose. So I have never won, and I've been here for 13 years. And
our paralegals usually win.
Yeah, they usually do. I guess I would expect.
I would expect 300,000. Yeah. But again, it's a guess game. It's nothing serious, so it could be more or less. Well, it doesn't matter.
I will give another perspective on that. So I always have some perspective. So let's say that if the economy's poor, right? And great, this is a different system where you're guaranteed to have, or the job market's poor anyway, you're guaranteed you get one chomp of the bit, right? The problem is if you register only with one company, well, shoot, if that company doesn't have a job for me come, April 1st, if that falls apart, well, I have lost the point of my registration. I think people are still going to do multiple registrations. Right?
So I think I take a second look at Emily's question. I think last year we had 700,000.
Yeah.
Oh, I expect 700 or more this year. Well, why not? Well, I will have to discount it'll be interesting because
some of there are certain businesses where the one business will put in and its related entities will put in registrations, like 5 registrations for a person. That has to go away, right? There's no sense of using your sister company or anything like that to register somebody twice, right?
So assuming this year is similar to last year from the economic trend, which is probably is similar.
Yeah. We were talking about tech layoffs this time last year as well. Yeah.
Yes.
Yeah.
The difference between the total number of the registrations last year compared to the total number of registration this year, the difference is the approximate number of fraudulent registrations.
Yeah. Yeah.
So it's going to have to be less than 700,000.
Yeah, sure.
I'm assuming because the economy were different. So I'm going to have to throw in. It'll be about 600,000 probably.
I don't think so. I think, but a lot of those registrations of the 780,000 were duplicates, right? Didn't they say they're like 326,000, 300-some thousand unique H-1B registrants?
Yeah, 400,000 duplicates.
Yeah, 400,000 duplicates. So I'm going to say it's got somewhere probably representing that true number. Well, okay. So if there's 300,000 individuals, you're right. You're seeing going to be some increase in registrations due to the fact that, well, shoot, I don't want trust company A. I want to go with company B and C and D just to make sure that if I'm selected, I get in. I get a job.
And it's now there's no fear of collusion to be in trouble. So last year people say, I just don't want to get in trouble. They're saying it's a bad idea. There's a lot of misinformation. Yeah. There could be a lot of misinformation this year as well. Yeah. But there could be a situation where they say, you know what? It looks like they're giving us the green light to file as many as possible, so let's go ahead and do it.
Yeah, I guess I would say it's probably, I would see a potential to be more than 400,000 applications.
Oh, I am pretty sure it's going to be with the duplications, yes. It's going to be more, I think it's going to be close to 600,000.
There's still an incentive for the individual to go out and find multiple companies to register for them, even though the companies won't engage in, plans with friends and sister companies, I think.
Yeah, so we're spending a lot of time with employers, talking to their prospective employees on private sessions. The idea is to develop the trust between the prospective future H-1B employees and the company, that there is a reputable firm involved. So we do a lot of that right now and starting to do a lot of that. These are private sessions that we do live on Teams or Zoom with a lot of people in India and their branches to help them out. So. So that's going on. So there's a lot of interest. People are nervous about the idea that now that it's out in the open and everybody can double and triple and quadruple register and it's legal. So
I'm going to choose the best, the company I think is. I don't have to go to the one company that got me selected. I get to go to the best company who's ever offering me the best. It puts power in the H-1B beneficiary's hands for sure.
Yeah, and I think honestly, I don't know about how people think, but people think differently. People evaluate what's important is differently. But I think you're gonna go with the company that is more likely to get you the job.
Yeah.
And you feel confident about their legal team, that this is not a company that's doing things in-house on the cheap.
Yeah.
So there's a lot of that psychology going on. I feel good with these people. They're going to get me there safely.
Yeah.
I've looked up their law firm. Their law firm is reputable. So there's a lot of that going on.
Yeah. Interesting time. Yeah. It's really the time for the employer to sell you on them rather than.
Yeah. So Emily has a second question.
Yeah.
Do we expect to see consistency, more movement in both row EB2 and EB3, given that USCIS is now using final action date means limited new I-485, given the filing chart is not an option?
Well, yeah, I forgot to look that up, but I guess Emily is confirming for us that USCIS decided to abide by final action dates this month, and this is me scrolling to the website right now, but. Do you expect to see? I'm going to presume that's true. I'm going to pull up the website right now. But do you think there's going to be more consistent movement in the final action dates?
I don't think it follows because of that. I think the connection. I'm just using mathematically the connection between the Visa Bulletin movement and the available visas in the pipeline, because the available visa in the pipeline was create the backlog and create the priority. These are not connected.
Yeah.
The number of visas available for second preference category and third preference category also are not the same, because you get the cross flow and the down flow. So the dynamics are so different that I don't think it necessarily follows in the direct relationship between the second preference and the third preference, simply because USCIS is using the final action date, in my opinion, in my mind, Emily. I mean, that's a factor, or multiple factors that dictate what the visa availability is, and therefore what the priority date is.
Yeah, I mean,
it's just my opinion.
My take is I expect to see slow movement. You know, that's something maybe consistent with what I've seen in the past. So yeah.
All right.
Let's go to our next question here from Ankit. Any chance of the new fiscal year for EB2 to reach near 2015 for India?
No, I don't think so.
I don't think so. So
looking at the dates, I mean 2012.
Yeah, what echoes in my mind is employment-based adjustment of status FAQs from USCIS. So a while back, maybe in September, USCIS updated their employment-based adjustment of status FAQs. And I'm going to put a link to it right here in the chat. Hopefully you guys are able to see that. And basically they said somewhere in there that we have enough cases in our hands for the next several fiscal years when it comes to India, EB2 and EB3.
Right.
And you know, the priority dates are in 2012 at this point.
Yeah.
Meaning, it doesn't seem very likely to me.
Yeah.
Yeah.
I agree.
Hey, here's a great question.
Well, take it, Brian, if you think it's great.
I'm willing to take questions I don't think are great, but I think this is a great one. Can we apply for premium processing on H1 on our own without attorney doing it? Well,
yeah, you can.
Premium processing without the you don't need the attorney to do it, but you need the employer to do it.
Yeah, but he's saying without an attorney doing it.
Well, you're giving them the trick answer. So I think I'm interpreting these words, and this is a great reason to bring up the fact that we're only getting snippets of information here, no attorney-client relationship established, because we're sort of interpreting questions as we get to them. But I'm interpreting, can we upgrade
on my own? You're saying without the employer.
Yeah. Can I basically say I want my H1B to be in premium processing? Can I make that happen myself without involving an attorney or even my employer? And that's how I'm choosing to interpret this question. And
well, it's an excellent point to make, because this question can be interpreted more than one way, and we should answer it in every way possible.
Okay.
So let's go into the way you're interpreting it. And the way you're interpreting is, can I, as an employee, without with the employer's knowledge, and even without the attorney's knowledge, file a premium processing upgrade and send it to USCIS with a check, and USCIS will accept it and process it? That's one of the way to answer. So what's the answer to that question?
No.
No. Okay, good. So I'm going to spin it a little bit more, so we're answering every potential possibility. Can the employee pay for the H-1B premium processing?
Don't look at me for a one-word answer to that one. That's a complex question.
Can the employee pay for the premium processing fee working through the employer and his attorney?
It is possible. But one has to be careful with it. And the short answer is Department of Labor rules for H-1Bs require that H-1B worker to get paid that H-1B wage. And if an employee is required to pay a fee, such as a premium processing fee, they can consider that, well, you're not making the prevailing wage as it's set forth in your H-1B petition, right? Now, there is wishy-washy policy that suggests that if it's done by the employee for their own benefit and not for the benefit of the employer, they may allow the employee to pay for premium processing.
Well, it's not wishy-washy.
It's reasonably clear. Yeah.
It's a clear rule that says, let's assume you had, God forbids, death in the family.
Sure.
And you go to your employer and say, I have death in the family, my H-1B is expired, I need my H-1B to travel next week. And I'm willing to pay for the premium processing, and he approves it and you pay. That's permissible.
Yeah.
If, however, the employer is transferring you from one job to the other, and the vendor or the end client wants a copy of the I-797 or the I-94 to confirm that you are in legal status, and then they have you pay for the premium processing upgrade. That's not permissible.
Yeah. We want you to go to Canada, and you need to have your H1B approved. No,
Yes.
Yeah, not permissible.
Yeah.
Yeah.
And then the last spin on this.
Oh, you have another spin?
Well, the last one,
Okay.
and then we'll move on. Can you pay with the premium processing without engaging the attorney working with the employer? So
Sure,
can the
okay,
employer
okay.
send the premium processing without the employer? You my own, meaning maybe you are the employer. I don't know.
Yeah. Do I have to tell my attorney I'm upgrading the case to premium
And
processing?
the answer is no.
Yeah.
The answer is yes. You can absolutely. You can do it. So those are all the scenarios.
Yeah, that's a meaty question for such
Well,
a short one.
it's because it's a short one. We had a lot of possibility. It was a good question.
Yeah, no, it's a question that I probably have to explain to somebody, once every week or two. Is happy to help you without have to talk to your employer about upgrading the premium processing first because.
Yeah, so I get a lot of people contacting me, and I don't like to sound short with them because the question they ask me, employees, potential H-1B candidate, they say, how much is the H-1B fee? How much you charge? Well, not all H-1Bs are born equal.
Sure.
There is an extra large, and there's a petite. There's a simple case, and there is a complex case. That's number one. But the second thing that I tell people, and the moment I tell them that, they just don't even reply. They kind of get upset when I tell them that I do not discuss H-1B filing fees with the employee because you are not required, you're required by law not to pay.
Yeah.
And therefore, just having this conversation makes me uncomfortable.
Yeah.
Send the employer over. I'll tell them after I understand the case with
We
the
keep
fees.
an eye. I recall a scenario where I think somebody was trying to retain us for an H-1B, and we realized the payment came for the employee, and we do a Control-Z on that and send it back because we cannot accept.
Yeah, a check comes from the employee.
Yeah.
The filing fee or the attorney fee comes from the employee, and we say no.
Can't do it.
We send that check back and say no, we cannot accept that check.
Yeah.
So we try to do things the right way, because the right way is the shortest distance between 2 points and the one that allows me to sleep well at night.
Well, yeah, it's a great way to make sure everybody's happy and everybody maintains their status is to comply with the rules. Yeah. So from Arindam, I hold a bachelor's degree in computer science and engineering from a reputed institute in India. Have got 23 years of experience in some of the most reputed software multinational companies. Well, if you're a multinational company, I'm thinking about L1 visas for you. But let's see where this question goes. In May 2012, a company in Bangalore, India, and worked for 16 months, and then came to the USA on an L1B visa in September 2013 through the same company. Well, clearly my brain's in the right place. L1B visas.
Wow, a lot of detail.
Yeah, I'm going to go through it here. Subsequently, the company filed my H-1B and Perm Labor Certification / I-140. My priority date is June 5th, 2015, EB2. My current grade is manager equivalent, and I have high compensation.
Oh my goodness.
Boy. Well, he's caught us live here, so I'm going to answer it. I was pursuing my company lawyer to file my petition in the EB1C for functional manager category. They declined EB1C since I was not holding a managerial title in India.
However, looking at my profile resume, they mentioned that they will make an argument, the EB1A. What do you think about the success possible EB1A? Well, thank you for the details. The EB1A stands on its own. I mean, very impressive background, but I need to know a little bit more.
That background, I guess you're saying is the background that person is given is not the one we need to know about for an EB1A, I guess is my.
Well, it sets the tone and the stage. It's a good background.
Oh yeah, I like hearing 23 years of experience, degree from a reputable university, working multinational companies. Sorry, I was just in such L1 mode, but
those are good stuff. But it is not what gets you there. It's the additional stuff. So we do a free, no cost evaluation for EB1A, EB1C as well.
Yeah. I love the idea. I love doing EB1C. It's a way to meet new companies.
Yeah. It's a good. They're fun to do.
Yeah.
but I need to know a heck of a lot more to give you an honest answer.
Yeah,
But you seem to be very competent in your field, and that's definitely a step in the right direction. But I need to know more.
Yeah, well, I mean, here, if there's an attorney out there that says they can make an argument for an EB1A for you, I mean,
Yeah,
I'll tell you.
I believe him, I guess.
Yeah, I mean, you can talk to another attorney and get another opinion. That's not so crazy. There's any number of competent immigration attorneys out there who can do employment visas, who can give you a
Second opinion. Yeah.
Yeah.
All right. Hari Guru got a statement here. Hi, Sam. I'm going to give you a break here since you read the last one, Brian.
Oh, that was a marathon a bit, yeah.
Hi, Sam and Brian. Do you here know the number of pending 45 employment-based Indian cases? Indian EB3 filing date stuck in August 12, 2012 for more than 15 months. Doesn't mean new cases are keep on getting regularly.
Maybe the first question: do we know the number of pending I-485 EB?
They're out there. I just don't remember them offhand. I mean, there's some data.
There was
out
like a court case from late maybe early 2022, maybe late 2022. About I just don't remember the numbers there. But again, USCIS recently in these FAQs said we have more than enough cases from India to chomp up the visa numbers for several fiscal years to come. Meaning, I guess it makes sense that you shouldn't see major movements. Well, definitely makes sense why I wouldn't expect to see movement beyond 2015, because that's the furthest the Visa Bulletin has made it for India.
And that's a lot of stuff are sitting in the warehouses.
Yeah, everybody who's in that warehouse must have a priority date before January 1st, 2015, if they're from India.
Yeah.
So we don't know the number, and so I think this. What do you think this person Hari means by? Does it mean new cases keep on getting regularly?
I don't understand that.
Well, I have an interpretation at least.
Yes.
Do you think? I think it's. Does that mean they keep on digging up people who are applying for a green card now because are they getting new cases for people? Why can't they move the date forward? Does that mean they're getting new people still filing with 2012 priority dates?
Why isn't the priority date moving beyond 2012? What's holding it from moving forward?
Yeah, and is it new cases coming in, right?
Well, there cannot be new cases coming in.
It can be. I'll give
with
you
the 2012 priority date?
Yeah, it's called. My employer at the time wouldn't support the filing. Wouldn't give me a supplement J. I was between employers at the time, and I couldn't file when my priority date was current. I was outside the United States when my priority date became current, and I was unable to go through consular processing. I had people who.
So what you're saying is, but these people have I-140s, Brian.
Yeah, but they have the priority date, and for whatever reason, didn't file back in October 2020, for example, or when everything rushed forward, the priority dates. Okay, are there tons of cases like that? Probably not. But
I'm just digesting. I'm not challenging your thoughts.
It sounded like what I heard was, Brian, that's a dumb idea, and you're crazy.
No, not at all. No, but just the thought that there is. I mean, it doesn't take. I mean, the number of visas allocated to EB3 India is 4,700, 4,600 a year or something. The 7%.
2,700.
Well, yeah. It's basically, if you do the math, you get the calculator is 140,000 times 28% times 7%.
Okay. 140, 123 times 0.28 times 0.07.
Yeah.
Yeah, 2744.
Yeah. So 2,744 cases a year.
Yeah.
So if they open the key on a dusty warehouse and they clean up the dust and they found 6,000 EB2 2012 cases.
Yeah,
that's 5 years.
Yeah.
Well, maybe not 5 years, but that's.
Oh, okay. Yeah,
that's 4 years.
It's 2 years at least.
2.5, 3 years.
You're talking about I-140s. Yeah. I mean,
that's
2.5 people.
Yeah, 2,700 I-140 is not a big number.
Well, 2007. 744 times family members.
And EB3. The problem with EB3. Are we talking EB3? Yeah. There's no cross flow or downflow to it. Everything gets sucked by EB2.
Yeah.
From EB1.
The EB2. They are. The India backlog is gobbling up everything there.
Obviously, EB3 rest of the
Sam,
world.
EB3 is ahead of. That's the funny thing, Sam. We're always talking about EB.
Yeah, but it's by the sheer volume of people who stuck in the system for so many years and moved on from EB2, EB3 to EB2.
Yeah.
And the rest of the world is backlogged, so there's nothing cross-flowing. 2023, although it's close, but nothing is coming.
Yeah, I mean, the final action date for India EB2 and EB3 is, months apart, 4 months apart. It's not particularly significant anymore.
Yeah.
Do you think that EB2 is going to finally go back ahead of EB3 anytime soon, Sam? It seems.
No.
Why not?
Because the number of people who are master's graduates coming in and applying for green card is large.
Yeah.
It's a lot of people.
What about?
And a lot of EB1s, EB2s, I guess, when they get 5 years, they apply for EB2.
Yeah, but it seems inevitable, though. Basically, so if I have a priority date, EB2 is at March of 2012. So if I have a March 15th, 2012 priority date, and I see I'm current in EB2, I'm going to downgrade to EB3 and get my green card now. Shouldn't it inevitably force, the EB3?
So there's a lot of EB3s are 2013, 2014, 2015 are waiting to see, I guess.
Yeah.
So yeah, maybe it will move back, right?
It seems logical to me that people who are in EB2, current in EB2 right now, not current in EB3, should be jumping into the.
Now, the only thing that would equalize EB2.
I've done transfer underlying basis recently for these people who are saying, "Hey, I'm in EP2, get me back into EB3." So yeah.
The only thing that I was trying to say here is ultimately they may equalize, and back to Emily's statement is because it may end up being that virtually 90% of the people or 95% of the people in EB2 or EB3 can jump back and forth. Yeah. Because how many people are coming in with a bachelor's degree only in this country on H-1B? How many green cards are you doing for masters? How many green cards are you doing for bachelors, Brian? Ratio.
It is very rare that one of our clients needs an EB3 green card. Either they have a master's degree, they got a U.S. master's degree typically, or have 5 years of experience prior to coming to the United States on the H-1B.
Most of our clients are people with not EB3 material.
It's probably, maybe 1 in 20 does an EB3.
Yeah, 1 in 20.
And it's usually, it's not like they don't have the experience. It's usually because, technically speaking, their foreign bachelor's degree is not equivalent to a U.S. bachelor's degree, et cetera, for the purpose of
3 bachelor guys.
So, how to contact us for a consultation? Well, we have a lovely link just below immigrationvisaattorney.com where you'll find our website, and we have a lovely contact form on that.
I personally reply to all these contacts. It's one of my hobbies. And you will get a reply from me. And if you want a consultation, we'll set you up with Brian, with me. You get to choose. Obviously, you're free to consult with any attorney of your choice, but if you want to contact us, you can follow this link. We don't over-push, we don't over-advertise. We are very busy lawyers and love to have more clients and good clients. So if you want to contact us, go to the website and contact us page. It comes to me, and from there, we'll set you up.
Yeah. Here's what I think is a great question, because this is something that comes up in consultations really, a whole lot for me, effectively. Can Indian born with UK citizenship work in the USA without applying for visa for 6 months? So it's a fundamental, I guess it's probably a visitor visa related question. 6 months, I guess, is the reason why I think that. Any other thoughts on this question, Sam?
Well, yeah, of course. I have a lot of thoughts onto this question. So if you're a UK citizen, you can definitely apply for a visa called E2 visa.
Yeah.
And that's a self-employment visa.
Well, yeah. I mean, okay. So you're interpreting this question okay. So, but without applying for a visa, Sam, without applying for a visa.
Like ESTA?
There's no okay.
There's no such thing as 6 months without applying for a visa.
Well, yeah, there's no such thing as 6 months without applying for a visa. So,
however, it's always good to answer the question that's not being asked.
Yeah, I'm very good at answering the question that is not being asked. So, if somebody is Indian born with UK citizenship, they would typically come to the United States on ESTA, a visa waiver, which allows somebody to enter the United States for 90 days right? It is comparable to a B1, B2 visitor visa, except you don't have to go to the consulate and apply for it. You do an online form. And
24 hours in advance at least.
yeah, I'll take your word for it, real quick. And the bottom line is, when you're in the United States on ESTA, you are not allowed to work, just like a visitor visa, you know?
Not extendable.
Not extendable, that's due 90-day entry.
Not transferable.
Yep.
And you need to leave within 90 days.
Yeah.
And it's not an employment visa.
Yeah. But if you change out this answer, maybe they're talking about 6 months, and 6 months is typically how long they'll allow you to stay on a visitor visa, or it's the maximum amount, right? You can't work on a visitor visa either. That's the bottom line on that one. What are you allowed to do on a business visitor visa, Sam?
Well, it's very interesting. I had
there's a lot of like weird fun exceptions.
I had the pleasure of doing a deep research on this about maybe 3 months ago.
Yeah.
For a interesting point, but the B visa and there's two types of visitor visa: one for pleasure and one for business. Yeah. And the pleasure is self-explanatory. We don't have to go into it too deep. Basically, sightseeing, visiting family and friends, and also occasions. Just it's pleasure, right? It's easy. You know what pleasure is. It's not work. It's not meetings. Not money making. It's nothing. The business visa has a lot of things to do.
Yeah,
and there's a lot of history to it. But
yeah, my generic answer is you're allowed to attend meetings and trainings on a business visitor visa, but you're referring to the 1,001 little exceptions of you can come and work service pursuant to a contract, a services agreement.
The answer you gave is right on, but there is employment allowed in extremely narrow scenarios, and we're not going to go through those.
Yeah,
we're not going to go through those.
Yeah.
So basically, you really are coming here for meeting, litigation, a board, if you're a board member, if you are providing a presentation, you're attending a religious, you're making, if you're a priest going for a religious.
Attending a conference.
Yeah, I mean, most of it is non-monetary, 99.9% of it.
Yeah.
Measuring, if you are a tailor, measuring somebody's suit.
There's all sorts of fun policy on this, but I want to come back around what you said, Sam. E-visas. We've never talked about, have we really talked about E2 visas in this venue here, live on YouTube, talking about employment stuff?
Yeah. And it is a wonderful visa.
Yeah.
And
it's an investor visa.
It's a great visa, and you can be in self-employment perpetually.
Yeah.
And perpetually meaning that for as long as you want to be. You want to be here on E2 visa forever.
Yeah, but I feel like I need to explain that self-employment you're talking about more. You can't just hop off a plane and say I'm working for myself. Let me provide services to your business as an independent contractor. You basically have to create a business in the United States and invest some money into it.
Create or purchase a business and invest $150,000, $100,000, and have a viable business. And you have to be qualified to run that business successfully. You have to show that you're going to create some employment, 1 or 2, 3, 4, whatever.
Yeah.
And
create something that extends beyond just supporting yourself in the United States.
Precisely, precisely. So that's an E2 visa. It's not available for Indian citizens, but it's available for a lot of citizens, including UK citizens. Now, for UK, however, has one twist to it. You have to be resident. You have to, UK, because there's a lot of UK citizens who live outside the UK. So the treaty between the United States and the UK has a provision in it of domicile. You must be domiciled in Great Britain.
Yeah. Well, I want to comment, why are Indian citizens ineligible for E2 visas? Because they're based upon treaties, as you alluded to. So the United States has treaties with, I think they're the Treaties of Commerce and Navigation treaties. I learned about those in law school. The only relevant thing to immigration I learned in law school. And they have those with certain countries, and India is not on the list of countries that has such a treaty. And basically these treaties apply for, hey, if somebody wants to start a business in our respective countries, you can provide visas for that purpose. So,
Yep.
Yeah.
Yep.
Yeah. So, from Krithika, excuse me.
If moving back to India within the same company, there must be a prior.
But H-1B is still active. What steps must be taken? So,
there's no steps to be taken. You're on an H-1B. You can come back on an H-1B if your employment is moving back permanently, temporary, and you can return to the U.S. within the validity period of that H-1B stamp and the validity period of the H-1B I-94. You're good. If it's beyond, you have to go back to the embassy and show that there is an actual job for you, and or extend the visa. And any time spent outside the U.S., not on H-1B, is time credited to you. So let's assume you come here for 1 year, but you go back home for 15 months working for the company, and then they need you back. You've already spent 1 year out of the 6, which is wonderful. You can even potentially apply for a green card here in the U.S., work in India for many years, and then come back on the rest of the H-1B time and then pursue your green card. Yeah. That's probably as general as I can get without getting myself too much trouble.
Yeah, when I think of if somebody's leaving, H-1B worker leaving the country, what are the obligations? I think of the employer's obligations. I think the employer, if they're being smart, conservative for their own benefit, they're probably going to withdraw an H-1B petition, and because. But
she's back on with the same employer, I believe.
Well, if it says if moving back to India within the same company, but H-1B is still active, the employer.
So the employer has obligation, but let's assume there is without digressing too much, since you made that comment.
I can't resist.
That's okay. That's a good comment. But if the employer can show that this employee is employed for them overseas and being paid for them overseas, I don't think there's a liability.
Yeah, I would tend to agree with you. But then again, we've read some Department of Labor opinions.
They are crazy.
Yeah, they are crazy.
But crazy facts bring about crazy rules.
Bad
facts makes bad cases, or bad cases makes bad law. Yeah. But in general, yeah. All right, sounds good. So we're approaching the hour, and we have an opportunity
we have just enough time to hit our questions.
Yeah, let's do it. All right, so if currently working on H-1B but have a valid EAD and advanced parole with pending adjustment status, use AP to travel back to the U.S., do we need to change to EAD for work, or do we continue on our current H-1B and renew H-1B when it is due? Okay, that's a great question. So you leave the country, you have both advanced parole and an H-1B. And then you return to the U.S. With your advanced parole. Yeah. And now what do you do? What is the option you have? I think the first question we ask, Brian, is whether or not you're returning back to the same employer.
That's a great bit of nuance there, yeah.
Okay, which is, most of the time, it is the case. Yeah. If you're coming back on advanced parole and then you moved on, opened up your own business, or you moved to a different company, it becomes a little bit muddier. But I'm going to make it the simple case. You go back to the same employer, which I'm assuming.
So when you leave, you're you're in the United States on H-1B status with Company A, leave, come back on advanced parole, you're returning to Company A.
Yes. Yeah. So you are deemed per a very old rule.
Not even a rule, a policy letter from like the year 2000. Yeah.
Right. But it is, the government letters sometimes have the effect of law.
Yeah.
You are deemed to have reestablished your H-1B.
Well, yeah, they will honor your work authorization when you return, and if you.
Although it was written with the idea that you don't have EAD in hand.
Yeah.
But it's been kind of loosely interpreted that you can really join back the same employer and get back on H-1B. You will be deemed or be viewed to have returned, and then you can extend your H-1B.
Yeah. You're only back on H-1B when you file your H-1B with your employer.
Yes.
Yeah.
But if let's say your EAD expired, you are deemed to continue working with that.
Pursuant to the H-1B work authorization.
Yes,
that makes sense to me.
So you're kind of covered.
Yeah.
And then you can renew the H-1B when it's due. That's correct. And then life goes on. Yeah. And then you're back on H-1B, by the way, and that's the only scenario you're back on H-1B. Now, changing the facts a little bit, we got a minute or two here, and I see one more question here, so I hope we covered everybody. But changing the fact a little bit, if you join a different employer, becomes a little bit more tricky.
The policy
and you can argue it both ways. but I don't want to take you into the peripheries of any rules in general. So I would say it's questionable.
Like I would think USCIS might approve that case, but did they rightfully approve it is the question that you have to ask yourself, and it's a little gray cloud that follows you.
Yeah, if you've joined the company that you worked for, but when the extension time came about, or maybe you took another employment and you filed an H-1B transfer, I've seen it being approved.
Yeah.
But that's also not explicitly stated in the letter.
There's a lot to think about on that front. So, from Sudha, what are the possible causes for delay in EAD for main applicants, even though dependents were approved quickly? Is Texas Service Center taking long?
Of course, they are the worst. The Texas Service Center is the most backlogged service center in just about every scenario I have looked up.
Yeah, you do a lot. I imagine when you're doing your consultations, you sometimes pull up the USCIS website.
I always do because I don't want to, because I looked it up yesterday, but maybe they've changed it today, and I want to give somebody the good news, right?
Yeah, I usually do it during consults as well.
It's basically government not able to keep up with demands, and too many cigarette breaks. We're not efficiency is not what we're known for in our government.
Yeah.
Nobody claims to be that we're efficient, unfortunately, and we suffer.
I would say I wouldn't put much stock in the fact that the main person didn't get their EAD and the dependents did. I don't think they think about it that way. I'd say just broad, they're a mess. Yeah, I would agree with you.
Yeah. All right, so we're not going to disappoint Harry.
Our last question asker here. But this is true, our last question that we will answer.
Yes.
So go ahead, Sam.
I have applied for advanced parole renewal in May of 2023, and it is still in process. My green card is EAD is expiring in August of 2024. I'm planning on applying for EAD extension next 15 days along with this application. Can I reapply for AP? Yes. What the heck? Why not?
The worst they'll do is tell you
Who knows where the heck that AP May 2023 is right now?
Well, consultation Brian, he does look up like processing times, and I tell people EAD processing times are bad, and AP processing times are way worse.
8 months, 9 months, most favorable.
Yeah, most favorable, and something.
17 months, I think, Texas Service.
You've convinced me, Sam, because I remember those numbers. The AP processing times are absolutely brutal. And the bottom line, I think our consistent answer on this has been, well, maybe they don't want you doing that, but they're not going to penalize you. There's no government filing fee, right? Typically, I guess they can reject a case for the one being in process. Sometimes they can send an RFE for saying, hey, which one do you want us to approve? But I mean,
there's no harm done, and do it before they change the regulations.
I'll ask the question.
There's a fee as of April 1st, right?
Oh, is there? Is that a fee on?
I believe so. I don't quote me on that. I believe there's a fee.
Well, do you think they can do anything to the pending by filing another one? Can they do anything?
No, absolutely not.
Yeah.
100% not.
Yeah.
I mean, it's been done for the last 30 years. I've been doing this, and the USCIS will come back and say, "Oh, we got 2 applications. Which one you want us to take care of?" They can issue an RFE, and you can reply to the RFE by withdrawing one of them.
I guess if they denied your first case because you filed a subsequent one, I would find a way to complain to the government about that, because that would be a bunch of baloney, because both cases were filed in good faith, and they can't just
With that, we conclude today's 1 hour with our friends here. Thank you guys for listening to us. 6 o'clock Monday, come back for more.